Thank you very much.
We're discussing the recent trend where we're seeing more and more governors being impeached by their respective county assemblies. Whether or not that's successful at the Senate, that's a different thing. But the fact that MCAs are now finding it easier to use the impeachment guillotine, if I may call it that. And the question was, are we seeing a misuse of this provision of the law that they can impeach? We're not seeing as much at the national level. Are we seeing a genuine push for oversight by MCAs, or is it just a way to hold their governors at ransom?
Good morning. Thank you very much. Two things. The first is that we must accept that the MCAs have that mandate under the County Governments Act. They cannot be faulted for exercising that mandate. In fact, at the very basic unit of the political edifice we call the county government, and in terms of the Constitution, the ward representative is the closest you can get to the common person, the public. And therefore, this ward representative has both the constitutional and the legal statutory mandate to speak for the people and say, we want to bring to heel, we want to stop the county governor's breach of the Constitution, violation of the law, acting in a manner that violates probably the principles and values in the Constitution, and so on and so forth. So the closest that we can get to the voice of the common person, the Wanjiko, the average person, is a ward representative. So I don't think they should be faulted for that. What we have seen is the politicization of the entire process, and I like what Mr. Moa said. Yes, Honorable Sakaja may not survive at the county level because the people are speaking, and if you listen to some of them, they have legitimate concerns, and they are saying that, look, the governor is so disaffiliated from the people, from the vision and from the suffering and the pain that they have on the ground. And the common person goes to who? The ward representative. The ward representative is supposed to be in that structure of the county government to listen to what the people are saying and take those issues to the county government, articulate them, and therefore have the people actually feel and experience what it means to have the government at that county level. The second issue, the entire impeachment process, right from the county government all the way to the Supreme Court, has, in my humble view, been thoroughly botched in this country. We had the opportunity, the Wambora case, actually the Wambora cases. Remember, Wambora was like the cat with the 9 lives, surviving back and forth. And you look at the legal interventions that were there, perfect, very good. But as we have progressed, look at the Honorable Mike Sonko's case, for instance, and I was involved in it. We have a judge who is now removed from the bench, who was part and participatory of that judicial process, after the Senate voted the way it was. And then you have senators coming out and saying that, oh, you know, we were voting against Governor Sonko, not because we saw and we heard and we were able to assess any evidence. There was no way to it. We were only moved by the political machinations that were there, which is why I agree with Honorable Kakuya saying that the Senate, probably the paradigm shift after and subsequent to the accusations of corruption by the president, and probably that's why we saw that the latest effort, failed at the Senate level. I don't know if that is a permanent shift or this was like a pushback, a sort of retaliatory action by the Senate saying that, look, Mr. President, you have been accusing us, probably this is your initiative, this is your project, and we will not affiliate ourselves with it. We want to vote against this impeachment. I don't know. So I'm saying the entire process of impeachment of a governor from that level, from the county level, all the way to the Supreme Court, has not been clear or informed by genuine constitutional and legislative process. Let me wind up by saying, we do not have, as we speak, a statute. The law should govern the impeachment process. What we have as a Senate are their standing orders. And this is at the whim of the Speaker of the Senate. And you say that, oh, you know, I have a preliminary objection. I'm raising an issue here because standing order number 25 says that I can raise a preliminary objection. Oh, you know, I'm going to subsume this into the main hearing. And all you're saying is that you cannot even stand and impeach this governor because a fundamental step was overlooked, or you do not have any material that can warrant you even to adjudicate on this. And what do? They subject the hapless governor. In my humble view, Honorable Kawera was in fact not impeached on those proper grounds. And she is a victim of that entire politicization.
So it is possible that there could be a misuse to some level. And now look at it politically. We're seeing, because we've been talking about the kind of influence that the executive may have on the houses of legislation, the National Assembly and the Senate at the national level. Yet we are now seeing someone of that level of Raila Odinga coming to intervene at this level, at the county assembly